Hey everyone, me Kevin here. So many people are convinced that Elon Musk has to buy Twitter, especially the armchair attorneys who spent 45 minutes searching through tweets on Twitter suggesting that, well, Elon Musk has waived his due diligence and therefore has to buy Twitter, and therefore don't worry that Twitter is down another 5% today and presenting a substantial arbitrage opportunity between the price of where it is now under $40 a share all the way up to $54.20, which is what Elon has agreed to pay. And if Elon doesn't complete the deal, well then everybody's just going to sue Elon and they'll get their money anyway. Those are what the arguments made, of course, by the armchair attorneys. But what we need to do is talk about reality here, because armchair attorneys on Twitter don't always have all of the facts, and I'm going to try my best to provide you a little bit more color in terms of what's actually going on. So first, there are a few things that are very helpful to know, and they have to do with timing, because the screenshots you see on Twitter don't always give you the proper timing. And it starts with the disclosure that we get on April 14th, which is actually a disclosure from the day before, April 13th. Let's pull that up. Here's what the disclosure says. On April 13th, the reporting person delivered a letter, blah, 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 basically April 13th here, right? But take a look at this. The proposal of Elon buying Twitter is non-binding and structured and agreed upon, conditioned upon other things, including confirmatory legal, business, regulatory, accounting, tax due diligence, and obviously financing due diligence would be included in this as well. So right here on the 14th disclosure, we know, okay, we've still got these contingencies, right? We still got to work out details of the transaction. Even though we're talking about it, there are a lot of things that could go wrong. Now, on the April 21st disclosure, we get this line right here. The proposal was and remains a non-binding. So we've got a non-binding proposal here, and this is sort of an amendment to the proposal, right? And it says here, at the time of delivery, the proposal was subject to the completion of financing and business due diligence, but is no longer subject to financing and due diligence, and is no longer subject to business due diligence. This is that quote you keep seeing going around on Twitter, that in these proposal disclosures, it says, hey, our proposal's good. We're no longer worried about business due diligence. But then, and the timing here is extremely important, then we get the merger agreement. That merger agreement gets disclosed on April 25th. And what that merger agreement shows is right here, section 6.4 of the merger agreement, which comes after this no due diligence disclosure that everybody keeps sharing on Twitter. This section here, 6.4, says that upon reasonable notice, the company, Twitter, shall provide Elon Musk property access, books and records of the company, and all information concerning the business that is reasonably requested. In other words, for Elon Musk to review and conduct diligence on. Now that's very important, because if this information doesn't corroborate what was previously publicly disclosed, then there could be an argument that either this is a contingency clause, which allows Elon Musk to cancel the transaction, or it allows Elon Musk to claim that he was fraudulently misled based on Twitter's public filings. Let's go back to the board right over this side.
This video is brought to you by Public. If you want to get a free stock worth all the way up to $1,000, make sure to go to metkevin.com/public. You can follow me there at MeetKevin, since it's a social brokeraging platform. You can check out the crypto they let you buy, the stocks they let you buy, and it's a great way to invest for the long term. Make sure to check out Public. They don't buy or sell your information, and they don't use payment for order flow. metkevin.com/public.
See, the SEC has a rule, Rule 10b-5, and it says that a company can be held liable for material omissions to their public information or material information that is misstated. And so there are two potential arguments here that could be made. One potential argument is that Elon Musk still has contingencies for due diligence, and therefore, if he wants to, he could either cancel the deal or renegotiate because of section 6.4 of the merger agreement, which came after this original proposal talk. So in other words, Elon Musk could make one argument that, hey, we're still contingent. Y'all are still required to provide us information. And if you're refusing to provide us the information that we want, then we could potentially cancel the deal because you're not following the contract, which we have a merger agreement. And this is why, if we pull up the iPad right now, this is why we get a letter right here saying that the issuer or Twitter is potentially in material breach of their obligations under the merger agreement, section 6.4. So Elon Musk's attorneys are saying, hey, look, here, right here, we're letting you know, we are putting you on notice that you are in material breach of your obligations under this agreement. So let's go back to the board here and try to wrap this up and understand this. Elon Musk has two potential arguments. Number one, Twitter still is required to provide information. If they don't provide information, they're actually breaching their agreement. So number one is just a straight up breach of the agreement. Number two, so potential argument number two is that, okay, fine, we got information which was the same information we got in the SEC reports. However, that information was misleading. And it is material information, because if we're buying a company that has 5 times as many bots as we thought it did, that is a material misstatement. Even though Twitter says in their annual 10K report, that the 5% estimate of bots could be higher than 5%, will this cover your butt line actually protect Twitter in an argument that, well, we're not misleading anyone, we said it could be higher? Sure. But how much higher? So all of this comes down to judgment, and ultimately will probably result in a lot of lawsuits. But Elon does have some potential ways of escaping this. Number one, arguing Twitter's not following the merger agreement, which again came after that due diligence disclosure, right? That merger agreement is the most recent document, which usually carries the most weight. Or he can make the argument that he had misleading material information, or both. Hear me, and I'm not an attorney. I don't think Elon Musk is necessarily in a position where he is forced to buy Twitter. So be careful with that argument.